stood at the front lines of law, leadership, and public service. Attorney Karen Jimeno, sharp, steady, a lawyer, an educator, turns complex issues into clear insight. Attorney Mike Toledo, seasoned, fearless, a strategist and communicator whose voice has shaped public understanding of law and governance. Together, they make the law accessible, connecting principles with real-life questions, confronting the issues that define our nation. This is ABOGADO!
Good evening and welcome to ABOGADO, where we examine not only what the law requires of public officials, but what happens when the law itself is later found wanting. I'm Attorney Mike Toledo.
And I'm Attorney Karen Jimeno. Tonight, we ask the question that will matter long after this complaint is resolved. It's a controversy that sits at the intersection of public finance, constitutional law, and criminal accountability. To understand what's at stake, let's look at how this controversy began.
In 2024, billions in PhilHealth and PDIC reserve funds were transferred to the National Treasury under a budget provision, later declared unconstitutional. Now, plunder and malversation complaints are before the Ombudsman. A harder question follows. If the law said do it, is obedience a crime? Some say yes. Public funds were diverted. Someone must be held accountable. Others say no. Officials should not be punished for following a law presumed valid until the court ruled otherwise. Where does good faith end? Where does accountability begin? Tonight, we draw that line. Can a public official be held criminally liable for implementing a law later declared unconstitutional?
Joining us tonight is Attorney Sonny Matula, President of the Federation of Free Workers and Chairperson of the Nagkaisa Labor Coalition. He's also the lead counsel for the petitioners in intervention in the landmark Supreme Court case challenging the constitutionality of the PhilHealth fund transfer.
Now also joining us is Attorney Reyes del Rosario, a public interest lawyer, educator, and a radio host. He is also a registered nurse and has an extensive background in student leadership, policy work, and community advocacy. Attorneys, mga panyero, welcome to ABOGADO.
Thank you, attorneys. Thank you for having us.
Maraming salamat.
Tonight's guests will begin with their opening statements, presenting their position. We then tackle two issues, followed by an open exchange where both guests engage directly. After the two subtopics, they'll give their closing reflections.
And now we begin with opening perspectives. The Supreme Court has declared unconstitutional the transfer of PhilHealth reserve funds to the National Treasury, a transfer carried out under a budget provision that officials treated as valid at that time. Yet plunder, technical malversation, and graft complaints now seek to hold those officials personally liable. Attorney Sonny, when a public official faithfully implements a law presumed valid at the time, can criminal liability still arise after that law is later declared unconstitutional? You have 2 minutes.
May dalawa pong point of view dyan. The first one is that there is no liability in the implementation of presumably valid law at the time before its declaration of unconstitutionality. And the other one is there is some liability if the public officials who implemented it is not in good faith and he knows that he is implementing an unlawful act.
Okay, thank you, Attorney Sonny. Short and sweet, but direct to the point.
Exactly.
Attorney Reyes, accountability is a cornerstone of public service. When billions in public funds are transferred under a measure later that is declared unconstitutional, should good faith end the inquiry? Or must officials still answer before the law? You have
Okay.
2 minutes.
Thank you. So basically, we're talking about two different issues here. The first is the constitutionality of that particular law, and the second one is the criminal liability of the persons involved. No? So basically, declaring a law unconstitutional does not automatically convict someone of criminal liability. In fact, the Supreme Court was actually very clear in its decision in the case of Pimentel versus House of Representatives that in the separate concurring opinions, the justices did mention all of the elements of the crimes that are involved here, for example, plunder, malversation, and they said that some of the elements were not present. So it basically tells us that in the determination of the constitutionality, it is not automatic that the criminal liability will also be imposed. Also, we have the presumption of regularity, which states that any act of a public official in following these laws, in the implementation of these laws, will presume to be valid and regular as part of their functions. And we also have, of course, the operative fact doctrine, which states that the effects of that particular law is presumed to be valid or is an operative fact not until it is declared unconstitutional. So these are things that will help the defendants in this case or the respondents in this case to for their defense. And also you've mentioned, Attorney Karen, you've mentioned also the what do you call this, the good faith, the good faith doctrine as well, which states that a person or a public official operating in good faith cannot be held accountable by the law.
Thank you so much, attorneys. When we return, we examine the line between constitutional error and criminal conduct. Does an unconstitutional act automatically become a punishable one? You're watching Abogado. Welcome back to Abogado. Tonight we ask, should officials face liability for implementing laws that are later declared unconstitutional? With us are Attorney Sonny Matula and Attorney Reyes del Rosario.
The Supreme Court invalidated the PhilHealth transfer and found grave abuse of discretion, but stopped short of finding any criminal liability. Several justices also expressed the view that the officials acted in good faith.
Attorney Sonny, is there a difference between an unconstitutional act and a criminal act? And when an official acts under a law presumed to be valid at that time, where should the line be drawn?
Of course, it's a factual issue. The reason why the Supreme Court did not take cognizance of the issue on criminal liability in the petition before it in the case of Pimentel versus House of Representatives. Actually, in our submission to the Supreme Court, we said that it's unconstitutional, and the other one is that there is some people who are criminally liable for the transfer of the fund, which is contrary to existing law and the Constitution. But the Supreme Court said that it's, of course, it's limited. A petition for certiorari is a civil action and limited only to that. And criminal liability probably will be taken care of another proceedings.
So you never put at issue yung criminal liability in a sense that you're filing it as a criminal
Now,
case.
we mentioned it as an issue to emphasize the gravity of the violation of the Constitution.
And this is relevant again because recently there are criminal cases now filed against certain officials, including Executive Secretary Ralph Recto.
Yes, after the Supreme Court decided on December 3, on December 7, we called the Ombudsman to do some fact-finding on the issue of this transfer of fund, because we understand that this is really questionable. The unappropriated program tumaas nung 2023 ng about 800 billion pesos. Anong 2024 ay 731 billion pesos. And that's the time that this provision was included in the General Appropriations Act. So it seems that there is some questionable matter that should be taken or be given appropriate action by our ombudsman in this particular case.
Thank you so much, Attorney Sonny. Now, Attorney Reyes, should the ombudsman give weight to the separate opinions finding good faith or conduct an independent assessment of intent and accountability?
Yeah, definitely. I think the ombudsman, I think Attorney Sonny is correct that the ombudsman should do a fact-finding investigation in this particular case. Because again, we have to remember that the petition filed before the Supreme Court was a petition for certiorari, which is a civil action and does not touch in any way with the criminal action. And also the correct jurisdiction or the correct sala for it to be tackled is not with the Supreme Court. It should be with the Sandigan Bayan, and the ombudsman can file that particular case. I totally agree that there should be an independent fact-finding investigation, but the separate opinions of the justices of the Supreme Court, we are now under the impression that they are of the opinion that there was no criminal liability involved, but it's not conclusive as to the criminal liability. So yeah, these are two different things. And again, I support that if there's going to be a fact-finding investigation with the ombudsman, then I'm very sure that the administration will be willing to cooperate with the ombudsman.
Thank you so much, Attorney Reyes. Now we'll open the floor for open discussions, and we have 6 minutes for this. So who wants to start? Perhaps we can start on the issue of the finding that there was grave abuse of discretion. What is the impact of that?
Well, the impact of that is, again, we have to go back to the presumption of regularity. And I think also I would like to raise the issue that has been going around social media because I'm very active din on social media. They are saying that bakit daw, they're questioning bakit daw nanggaling sa GAA 2026 ang bayad doon sa PhilHealth na 60 billion na transfer. And that's a valid question, but you have to remember that the 60 billion was utilized by the National Treasury. So it is just right that the National Treasury should also return that particular amount to PhilHealth. So yeah, I think that is an issue that needs to be resolved as well. Na tama ba na nanggaling sa National Treasury ang pambayad sa PhilHealth?
Oo nga, to pick up from that, yun yung reklamo ng mga iba, including Dr. Tony Liachon, na bakit twice pinapabayad yung taong bayan. Una, nung kinuha yung 60 billion pesos from PhilHealth funds, but now that nung pinasoli siya ni President Bongbong Marcos, hindi immediately sinoli. Parang nakita natin yung pagsoli dito na sa budget for 2026. But to Attorney Reyes' point, parang nanggaling din sa taxpayers, so nanggaling sa National Treasury, no?
I guess that would even be a subject of another issue or another case.
Yeah, I understand that because the decision of the Supreme Court directed the government to include that in the 2026 budget. So that's part of the decision. And I think that's still good because we return the fund to the PhilHealth. Kasi pag walang order na yun, baka maubusan na ng pondo ang PhilHealth. Marami mga ospital ang hindi pa nababayaran.
Alam ko yan kasi marami akong hospital na kilala na hindi pa nababayaran ngayon, hindi pa na-reimburse. No? Pero to both of you, okay, no? Pinag-usapan natin no? Itong constitutionality, accountability. But di ba sa inyong pananaw, kung retroactively a public official is found criminal or administratively or civilly liable for acts he has committed following a law that was valid at that time, would that not somehow be a big blow to good governance, to the implementation of the laws for providing public services? For example, may batas, ito dapat gawin mo. Pero hindi mo ginagawa because you're making them think, wow, this law may become unconstitutional or illegal in a few days or in a few years or in a few months. Paano yan ngayon? Di ba masama yun?
But following that line of argument, partner, di ba, yung naging batas kasi na basihan nito was the General Appropriations Act that was passed
by Congress.
Yes. And then they included in that provision that the unutilized savings of certain government-owned corporations, and including PhilHealth, should be or could be transferred. So, kung ganon, hindi ba yung, I guess I'll go to Attorney Sonny's point kanina, that there has to be at least some good faith, or if you know at the time that there is irregularity in in the passage of a law or yung dun sa provision, then what, you should not act on it? Ano ba yung tama?
I
Yung
think if
question
you
ni Atty.
look at the special provision 1 paragraph D, chapter 43,
Of the General Appropriations Act.
Appropriations Act, authorizing the transfer of excess funds or savings from government-owned and controlled corporations and directing the Secretary of Finance to implement it. You can already say, if you know constitutional law, you can already say the provision is contrary to the existing constitution and the existing law. For example, Section 11 of the Universal Health
Healthcare,
Act,
yeah.
the Republic Act 11223, provides that if there is an exist fund or there is a savings, it should go first to the reserve funds, the ceiling of about 2-year expenditure. And if there is still an exist on that, there is a need to invest it, to increase or to have income for the funds. And if there is still more, then you can increase the benefit, and or the other one is to decrease the contribution. So, and following that, another provision said that the funds of PhilHealth cannot be returned or cannot be transferred to the government or any agencies or even government-owned and controlled corporations. So that is clear in the Universal Health Act. Other than that, Article 25, Paragraph 2 of the Constitution is clear that no money shall be transferred from that is already appropriated. And the exception is the President can only do that if there are savings. In this particular case, it's the Secretary, not the President, who transferred the funds. So it appears that there is already a clear provisions of the Constitution which is contrary to this General Appropriations Act, and Section or Article 7 of the Civil Code states that if the law or act is contrary to the provisions of the Constitution, it is void and it has no
Void ab
effect
initio.
at all.
Yeah.
So,
The supremacy of the Constitution.
Oo. So kung gano'n, Attorney Ace, ano yung magiging duty nung executive? Kung nagpasa ng batas, and interestingly, partner, di ba, this was the time nung pinasa tong General Appropriations Act na ito. Ang chairman pa ng Committee on Appropriations was former or then Congressman Zaldico.
Yes.
So yun yung maraming later na raise na questions and anomaly about that specific budget, diba? That specific General Appropriation Act. But if you were the executive at pinasa yun ng Congress, what should you do? Instead of implementing, punta ka sa court to question? What do you think, Attorney Ace?
Yeah, we have to remember that the GAA is a law. Batas po siya. So there is a presumption of validity and constitutionality in that particular law. So kung ako ang executive, I would implement what that law states. Because, again, it's only the Supreme Court who can declare that that particular law is unconstitutional, thus you should not follow it. No, so in that particular case, baka nga masubject pa sila to petition for mandamus if they don't follow that particular law. For those who are watching, yung mandamus po is compelling someone to do his official duty, which in this case is dictated by a law. So yun po yung number one. Number two po, we also have to look at timelines. The GAA 2024 was passed, of course, during the budget cycle of 2023, right? So E.S. Recto was appointed as the DOF Secretary January 2024. So basically, nandun na po yung batas just for him to implement. No, so we have to be very clear about that as well.
Yun nga, partner unang-una may batas And then there are rules, there are laws that will fine a public official liable if he does not act pursuant to a mandate of the law, di ba? Saka para sa akin, alam mo, Attorney Sonny, Attorney Reyes, if you're a government official and you are afraid of acting because you don't like cases filed against you, then don't join government. Dapat hindi ka matakot na kasuhan ka kung tatanggapin mo ang pwesto sa gobyerno.
Part of the job.
pagkakalam ko, Panyero, si kung nakita naman lang clearly unconstitutional, the President has the power to veto. So the President should have done his job looking at that provision of the General Appropriations Act. Actually, there is some questionable issue really because the proposal of the Executive Department is about 232 million in the unappropriated program. But the House and the Senate approved threefold, about 800 plus or 731 million plus of unappropriated program no? Or unprogrammed appropriation. So diyan na makikita mo agad. Tapos dinagdag ito na kukuha sa exist fund na contrary to the existing law na ilalagay doon para punduhan yung unprogrammed appropriation. So, makikita mo na mayroong problema talaga. Kaya palagay ko kung nagkonsulta siguro sa good lawyers ng Presidente, palagay ko ay vinito na yan. No?
Thank you so much, attorneys. Up next, we have another interesting discussion, the specific complaints before the Ombudsman. Can plunder exist without personal enrichment? And where does good faith fit in? You're watching Abogado.
Welcome back and thanks for joining us. You're still watching Abogado. We now turn from constitutional theory to criminal law. The complaints allege plunder, technical malversation, and graft. Each offense has different elements and may lead to different conclusions on liability.
Attorney Sonny, can there be plunder where funds move only between government accounts, no personal enrichment is alleged, and the money has since been returned? You have 2 minutes.
Yeah, I don't think there is plunder in that particular case because in plunder under Republic Act 7080, there is a person or in association with other person who amazes wealth of about ill-gotten wealth of about 60,000 or 60 million, 50 million pesos. And kung wala namang ganong allegation, ay mahirapan. Kaya kinakailangan talaga yung panawagan namin na magkaroon ng fact-finding itong ating Office of the Ombudsman para makalkal yung mga pangyayari at makonect, lalo na ngayong tumataas yung issue ng scandal sa flood control fund. Kasi yung sa 60 billion at yung 107 billion mula sa PDIC, ay maraming pumunta doon sa tinatawag na unprogrammed appropriations. Yung sa 60 billion lang ng PhilHealth ay about 27 billion ang pumunta sa parang legitimate din kasi sa allowance ng mga health workers at doon sa non-health workers during the pandemic. Pero yung 13 billion doon ay pumunta sa unappropriated or unprogrammed appropriation. Kaya palagay ko ay dapat tingnan ito at kalkalin. No? Kung sa kasalukuyan lang yung tinitingnan natin, palagay ko hindi magpa-prosper yung plunder.
Salamat, Attorney Sonny. Now, Attorney Reyes, does technical malversation become the strongest complaint? Because, as we all know, in technical malversation, intent is not necessary, it's not required. No. Or does the law authorizing the transfer change the analysis?
Okay. So under technical malversation, under revised penal code, there are 3 elements. The first one is that person must be a public official, which is correct in this case. The second one is that particular funds questioned is under the care of that particular person or under the care of that particular office. And the third one is that there was a transfer to another of funds that it was not intended for originally. No? So I think the second element is not here. Right? So there's no technical malversation because, first of all, the funds was not under the care of the Department of Finance. The funds was under the care of the National Treasury, of the Bureau of Treasury. So basically, that in itself will tell us. And even the separate concurring opinions of the Justices Alameda, Justices Rosario, Justice Garland, they all said that the money was not under the care of the Department of Finance during that time.
Thank you so much, Attorney Reyes. Now we'll open the floor for another open discussion. And we have 6 minutes for this. I suppose we can pick up from what Attorney Sonny was saying na dapat kalkalin ito ng ombudsman. So, let's say magkaroon ng forensic examination of saan napunta yung 60 billion na initially transfer from PhilHealth to the, at some of them went to unprogrammed appropriations. Kung napunta nga yung iba sa flood control projects, then you have this whole line of kung saan napunta, pero kanino mo dapat ilagay yung liability for that type of transfer at sa pagpunta niya eventually sa flood control.
So kung may conspiracy dyan, lahat ng mga person involved, ma-identify yung mga taong involved, sila ay liable sa crime of plunder kasi more than 50 billion ang involved sa flood control. Trillion nga, no? Trillion nga ang involved. Kaya maaring kinakailangan talaga i-identify. So that is a question of fact na i-identify ng fact-finding body o ng mga prosecutors. No? Kaya mahababang trabaho, malaking trabaho, pero dapat tutukan ito sapagkat napakalaking at seryosong problema. Sabi namin doon sa oral argument, this is a serious offense kasi it's contrary to the principle of social justice. 60 million was taken away from those who have less in life. No? Na nangangailangan ng pondong ito, sila pa ang kinunan mo ng pera tapos binigay mo doon sa program appropriation, malaking kasalanan yan. No? Pinahirapan mo ang mamahirap.
Hindi ba pwedeng sabihin na good faith could be a defense? Kung wala namang malicious intent, he acted in good faith, following the provisions of the law, hindi ba pwedeng magandang depensa yun?
Maring gawing depensa yun. No? Maring depensa yun. Pero sa aming nakikita ay kung klaro naman talaga na yung provision ng batas na ito ay salungat sa saligang batas at sa existing na mga batas, yung General Appropriation Act is a general law, cannot repeal or amend a special law like the Universal Health Act o itong Syntax Act. Ano? Kasi specific kasi yung nagsasabi na yung pondo na nilagay sa PhilHealth ay para sa PhilHealth lamang at hindi pwedeng dadalhin sa ibang mga ahensya.
Yeah, I think good faith can be a good defense here, no? Because even the Supreme Court noted several instances or several actions done by the government, especially the ones accused here, sila E.S. Recto, that will tell us that there's good faith involved because they actually consulted relevant agencies in the transfer of these funds, no? So including that of yung the office that is mandated to supervise yung mga GOCCs, they also consulted that, no? And they agreed that it was okay to transfer that particular fund. So good faith is there. And again, there is also a presumption of regularity. So I think the plunder case even will not prosper because there was no personal gain on the part of the accused. No? So we cannot really prove that they actually, unless we have a fact-finding investigation by the ombudsman, we can't really prove right now na binulsa nila yung pondong yon. And that's the only time that it can be plunder, if binulsa siya.
No, partner, talagang importante yung presumption of regularity in my view. No? Kasi isipin mo, pag walang presumption and if you expect the public official to be a prophet, that he can foresee that the law is going to be taken down as being unconstitutional, therefore void ab initio, hindi kikilos yan. So it will be governance of paralysis in governance. Matatakot ang tao eh. O bago siya kikilos, hihingi pa siya ng bisbis maybe sa Supreme Court or any court for that matter. No? Wherein there is already a procedure in the executive department wherein different agencies would review. Kumbaga may sinusundan na proseso. Diba? Therefore, may presumption na regular lahat. Kaya kung nagkamali man, sa tingin ko, dapat naman siguro they should not be held personally accountable, whether it be administrative or criminal.
So to that point, what would be a safeguard? So this goes just beyond a legal question, but in terms of prudence and practicality.
Yes.
Kung ikaw yung executive and then even if you have doubts as to whether an act was valid, because meron din nga tayong effect sa law na pagka void and ab initio, magiging void and ab initio din yung acts done pursuant to a law, di ba? So, kung ganun man, should an executive kung gusto niya maging extra careful, get the opinion of the Office of the Solicitor General or the Council of GOCC Council to interpret a law, and therefore will that add a security blanket for future liability?
Well, I believe that's actually part of the budget deliberations. No? During the budget deliberations, they actually have a chance to invite all of these relevant agencies in order for them to discuss whether or not the funds that are being allocated or the budget that, any acts that they want to do with the budget are constitutional. No? So that's part of it. And we believe that these particular agencies are experts for the particular mandate that they have. So that's why we consult them. And I think that's a good point. But it is not a blanket immunity, but I think it is an added layer of safeguards for the Congress and at the same time for the executive in the implementation of these budget laws.
Alam mo, partner, talagang maybe it's good also to just talk briefly again on the doctrine of operative fact, no? Para maintindihan natin mga tagapakinig, ano bang ibig sabihin nito? Ibig sabihin, yung kung ano, whatever you've done at that time, and if it was valid, it will be considered valid, even if after it was declared void by a subsequent law or by a decision of the Supreme Court, for example. And the reason for that, di ba, mga panyeros, the reason for that is to prevent injustice. Because there are legal consequences to the acts that you committed at the time pursuant to following that certain law. Paano naman yung mga taong nag-rely dun sa kilos mo, sa decision mo, based on that law, which at that time was still valid? So it's really also for equity, to prevent injustice, and also to prevent administrative or governance chaos, di ba? Ano sa panahon mo, Attorney?
Tama naman po yun na if there is a law which was declared later on as unconstitutional and the public official in good faith relied on that particular law, then hindi naman siya kumita, palagay ko ay wala siyang problema. Yung problema natin dito, if there is conspiracy, some sort of that, because that is an element or part of plunder. There is conspiracy and bad faith. Makikita natin na kinakailangan, palagay ko talaga, na ungkatin ng ating ombudsman ang mga pangyayaring ito. Kasi kaduda-duda talaga eh. Yung 2023, 800 billion. Pinakamataas yan na unprogrammed appropriation. 731 billion noong 2024, during the time na na-insert itong provision na ito. At during this time, ay marami ang napag-alaman at naimbestigahan, nag-commit ng pagnanakaw sa gobyerno. So, palagay ko, okay lang naman yun na nag-implement ka ng batas dahil in good faith ka, pero mahirap yung in-implement mo ang batas na alam mo naman na kumita yung marami. At illegal yung pagbibigay sa kanila ng pera ng gobyerno.
But here's my question. Kung sakali man na merong restitution, and yun yung point kanina ni Attorney Reyes, na that's still an open issue, di ba? Kung totoo bang may restitution in a sense, because kung napunta man yung part of that 60 billion pesos went to unprogrammed appropriations, and this time nung pinasoli siya ng Presidente at saka ng Supreme Court sa PhilHealth, nanggaling din siya sa National Treasury, which would be coming from taxpayers' funds. Was there true restitution in a sense? Or kailangan bang habulin yung mga napaglagyan ng program appropriations at sa kanila ipasole yung 60 billion?
Good question.
I believe there's restitution here because again, sino bang nag-benefit doon sa 60 billion na yun or sino bang gumamit ng pondo ng 60 billion na yun? We have to understand that it was returned to the National Treasury and it was appropriated for programs of the government. So that's number one. So basically, there's a presumption of regularity din doon na parang ginamit talaga siya for the benefit of the Filipino people. That's number one. So since ang National Treasury ang gumamit, ang nag-utilize ang national government, it's just right that the National Treasury will also return the money. So dapat National Treasury din, the national government rin, ang magbabayad ng 60 billion.
What about you, Attorney Sonny?
Narinig ko na yung argument na kasi nawala ang pera, tapos ang binigay mo ay yung pera din ng mga tao na kinuna mo ng pera. Parang double whammy. Tapos may pangatlo pa yung opportunity na na-miss. Maraming mga hospital hindi nabayaran, maraming mga Pilipino ang
Alam ko yun. Hospital na hindi nabayaran.
Hindi rin naka-benefit doon sa kasi wala na daw pera o mahina atang absorption ng PhilHealth sa paggamit ng pera, no? So tatlo ang parang tinamaan dito. So palagay ko ay kinakailangan talagang i-review ng ating pamahalaan yung ating universal healthcare program. At siyempre yung ating mga mambabatas ay tingnan talaga yung kanilang mga ginagawa na hindi contrary to the Constitution and to the existing law that we have now. Kasi maraming matatanamaan ng mga Pilipino at marami ang mawawala ng mga oportunidad na maari sanang nakabenepisyo na yung ating mga kapwa Pilipino during the time.
Yeah, well, can I just add something?
Yes, of
I
course.
totally agree because even the syntax law is very clear na yung intention niya, 85% of the entire syntax will go to PhilHealth. Pero ang nangyayari ngayon, not even I think 20%, 30% lang yung napupunta sa PhilHealth. That in itself, dapat the Congress should be, dapat nga sila yung gumawa ng batas, dapat i-follow talaga nila. Pero yun nga, I agree that PhilHealth should have more funds though. But we also have to remember that PhilHealth is a corporation. It's an income-generating agency of government, GOCC. So basically, meron siyang reserved coffers, o may reserved fund siya that they can utilize for projects for the people or in the implementation of the Universal Healthcare Act. So I don't think the 60 billion itself, personally, I don't think the 60 billion itself made a dent because I was able to talk to PhilHealth officials and they mentioned that yung 60 billion na yon, it actually didn't affect them operationally because they have reserve funds and yun yung ginamit nila during the time na wala pa yung 60 billion.
Okay.
So, yeah.
And on that question, I mean, to that point pala, di sana taasan nila yung contribution nila tuwing merong na-hospital as a PhilHealth member, no? Sana taasan nila at bayaran nila yung mga hospital na hindi nababayaran, no?
I think it's more on the implementation and operationalization of the budget. I don't think it's because of the 60 billion na hindi nabayaran yung mga hospitals.
Okay, thank you.
Yung kabalintunaan lang noon ay during that time, tinanggal yung 60 billion earlier, in-increasean ang PhilHealth contribution. Oo, so
Yeah, I agree naman.
mahirap paniwalaan itong ganitong sitwasyon, ano? In-increase mo nga yung premium tapos tinanggal mo yung 60 billion at sinasabi mo na sobra na ang pera ng PhilHealth.
Oo nga. Oo. Talagang mukhang maraming kailangan himayin, no? This is not just about the PhilHealth transfer of funds. It really goes into the implementation and so many other issues. Thank you, attorneys. When we return, closing reflections on our central question. Should officials face liability for implementing laws later declared unconstitutional? This is Abogado.
Welcome back. You're still watching Abogado. From constitutional presumptions and separate opinions to plunder, technical malversation, and graft, our robust discussion tonight has examined the line between accountability and good faith governance.
At its core, the question is no longer whether the transfer was unconstitutional. It is whether implementing a law presumed valid can later give rise to criminal liability. We now ask for closing reflections. Attorney Sonny, your final statement.
Sa aking paningin, an unconstitutional law which was implemented by a public official na wala namang kumita, it was implemented in good faith, palagay ko ay walang liability siya. But if the public official knows well that the act of Congress which he is implementing is to pursue a certain corrupt act in particular, palagay ko ay dapat maging liable sila. Dito sa issue ng PhilHealth ay napaka-importante ang fact-finding na gagawin ng ombudsman para mahalungkat ang katotohanan sapagkat sa palagay ko ay may marami kasing red dots yan na
Red flags.
na red flags na makikita tayo na maaring magtuturo na mayroong ginawa talaga na korupsyon dito sa mga unprogrammed appropriation. At sinusundan ko at sang-ayon ako doon sa sinabi ni Justice Hernando na itong unprogrammed appropriation, dapat tanggalin niya sapagkat yan po ay unconstitutional. Nagbibigay sa executive department ng indiscriminatory power para gamitin ang pondo ng gobyerno na walang control ang Kongreso o ang legislative department.
And I guess to your point, Attorney Sonny, yung conspiracy nga, kung may ma-establish na conspiracy pala to, then mawawala yung parang sinasabi mong good faith in implementing.
Tama po, oo.
Okay.
Ang ano lang dyan, partner, like plunder, conspiracy, mas mahirap patunayan.
Yes.
Kaya nga sinasabi nila, low-hanging fruit, like sa flood control projects, tirahin na sa malversation through falsification of public documents. Anyway, unbailable din yun, may ceiling yun eh. Pero pag plunder, medyo mas mahirap i-prove. Kasi, Thank you, Attorney Sonny. Maganda talaga yung mga reflections mo.
Maraming salamat po at mabuhay po kayo. Salamat sa pag-imbita.
Of course. Now, Attorney Reyes, ikaw naman, closing reflections.
Okay, basically, I think we have discussed everything already comprehensively. Now, I would just like to focus on someone who is very active on social media. I think we need to counter a lot of the disinformation and fake news regarding this particular issue. I think it's important, of course, for lawyers. Kasi dumadami yung abogado sa Facebook eh. Kahit hindi naman sana abogado, but they are...
Buti na lang isa lang abogado show.
Correct. Tama po. And I'm very grateful to the Abogado page because you're really very hard-hitting kayo pagdating sa mga fake news eh. So, I think the lesson here is that we need to read more, to research more, and to follow lawyers who are, who can provide these legal with legal advice. Baka sabihin na naman may legal back, but legal advice. So again, I think the constitutionality issue is not of question anymore. I think it's more on the criminal liability. And in determining criminal liability, it's still with the prosecution. Nasa prosecution pa rin ang burden of proof and evidence in order to say that these people accused have criminal liability. And in this case, I think I will side with the separate concurring opinions of the justices of the Supreme Court, which basically states that there are absent elements, in the case of plunder, technical malversation, and graft. And I don't think na this case will actually prosper.
Thank you so much to both our attorneys here. It was really a very insightful discussion, no,
Definitely,
partner? Kasi
partner.
tama rin si Attorney Reyes dahil nga mainit yung issue na ito, pero kung kung ano-anong mga opinions ang matatanggap mo. And it's hard to understand, ano ba dito yung tama, di ba?
And of course, we hope that programs such as this, Abogado, ay nagbibigay ng kahit paanong clarity sa mga issue na ito na quite complex and complicated as well. But we do hope na talagang na-educate natin ang taong bayan sa programa ito.
Again, our thanks to Attorney Sonny Matula and Attorney Reyes del Rosario for helping us navigate one of the most consequential accountability questions facing public officials today.
Because in the end, public service, public trust, requires both obedience to the law and fidelity to the Constitution. And when those two appear to collide, the challenge is determining where mistake ends and criminal liability begins.
And in a constitutional democracy, accountability must be real. But so too must the protections afforded to those who act under the authority of law. This is Abogado. Good night.